Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, I'm sure you've heard of the saying, the road to hell is paved with good intentions. We're going to examine how that saying can apply to estate planning. What's our topic today? The three questions to ask about why traditional estate planning often fails families. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. Despite careful drafting, estate plans frequently unravel due to overlooked gaps, leading to family disputes, delayed inheritance, and eroded wealth, issues that affect 60% of families, according to surveys by the American Bar Association. High-profile cases like the ongoing battle over Jimmy Buffett's estate highlight how missing elements such as clear communication, the strategic use of co-trustees, and thorough planning can turn a legacy into litigation. Understanding these failures isn't just academic, it's essential for ensuring your plan withstands real-life challenges, preserves assets, and maintains family unity. We'll address them as we explore the three questions to ask about why traditional estate planning often fails family. Joining us is returning guest Debbie Babb. She is a third-generation Los Angeles attorney who specializes in estate planning for complex family dynamics, including blended families and high net worth individuals. Debbie, great to see you again. Thank you for making time for me. I really appreciate it.
Thank you for having me back. It's so fun to see you today.
Yes, well, first thing I got to talk about is that, so Debbie, for those who don't know Debbie, she has a weekly newsletter. I get it every week, very personalized, always talks a little bit about what's going on in her day-to-day life, and she always brings up interesting stories. And I want you to know, Debbie, I read them. Just so you wonder, do I get it and go, oh, click, gone? No, I actually, when yours comes in, I stop and I read them, just so you know. And one in particular, and I'm going to bring it up right now. I'm going to try some wizardry here, and hopefully I don't lose you forever. But this article that you sent me, and I gotta see if the date is on it. It was earlier in the year. Don't notice the date, but that doesn't matter. When paradise turns to pain, Jimmy Buffett's estate battle. And it's an incredible story about Jimmy, how he built a $275 million estate. And unfortunately, it kind of all fell apart, or they're having some serious challenges now. And we're going to get into it, but I want to commend you, first of all, for highlighting that story, because when I read it, I don't think I was two-thirds through the article. And I'm saying to myself, well, that's a podcast right there. That's we got to get Debbie. I emailed you before I got through the article. So maybe before we get to our questions, how about I'm going to give you a chance here just to outline an overview of what took place here, just to bring the audience up to speed on why we're bringing this to the forefront.
Yes, of course. So Jimmy Buffett wasn't just a singer, he was an entire brand.
No kidding.
Between
Yes.
Margaritaville, his restaurant chains, resorts, and merchandise, he built a business empire worth nearly $1 billion by the time he passed in 2023. And like many successful entrepreneurs, Buffett tried to plan carefully. He had an updated trust meant to take care of his wife, Jane, his children, and several charities. Uh, like so far, everything's good, right? He appointed both his wife, Jane, and his longtime accountant, Richard Mosenter, as co-trustees to manage this, $275 million trust, nearly $1 billion. And the trust was designed to provide for Jane during her lifetime, with their three children inheriting what is left. But
Sounds pretty standard procedure so far, although we know there's one little crinkle here, but I don't want to break the story yet. So carry on.
yeah, yeah, yeah. No, I know. It all sounds good, right? But despite having legal documents in place and an updated plan, this plan has created a nightmare for his family. Jane filed a lawsuit in June of this year seeking to remove Mosenter as co-trustee, claiming that he's been openly hostile and adversarial toward her while collecting, you're not going to believe this, $1.7 million annually in fees. She alleges he refused to provide basic financial information about her own trust and projected annual income of only $2 million from $275 million in
That's a
assets.
fairly conservative burn rate there. I can tell you in the world of financial planning, that would be fairly light.
Yeah, like it's less than a
I
1%.
was going to say, I mean, we tell clients if you're say in your mid 60s, early 70s, your portfolio should be able to stand a burn rate probably, and I hopefully my peers won't disagree with me here, but 3.5% is fairly reasonable burn rate on, or we call it spending as a percentage of liquid assets. So distributing $1 million to her, or 1%, pardon me, a year, $2 million, 1% a year is pretty conservative.
Yeah, yeah. And then the accountant, he fired back with his own lawsuit, and he claimed that Jimmy had repeatedly expressed concerns regarding his wife's ability to manage and control his assets, and that the trust was deliberately structured to prevent Jane from having absolute control. And the accountant is alleging that Jane's been uncooperative and has interfered with his management decisions. And this battle, it illustrates why traditional estate planning often fails family. Even when the documents are appropriately drafted and regularly update. The root of this conflict isn't in the documents themselves. It's something so much more fundamental that so many families overlook, regardless of how many assets they have, and that is effective communication. The problem here wasn't necessarily the documents, it was the lack of clear communication about how these co-trustees were meant to work together. And there wasn't explicit guidance from Buffett about who would have the final say. And, as we are seeing it unplay now, without a shared understanding of Buffett's long-term vision, the co-trustee relationship has become incredibly strained. Um, Basically, it's a reminder that even when you have all the right paperwork, the human element can still cause the plan to unravel.
In the opening, I mentioned how missing elements can turn a legacy into litigation, and obviously that's the case with the Buffett. I do have one question. I just thought of this as you're sharing some thoughts there. Do we know if the trustee's fee is tied directly to the value, or is it a fixed amount he's receiving? I have a reason for asking. If you don't know, it's okay. I'm just thinking off
Yeah,
the top.
I'm sorry, I don't know.
I wonder because I'm thinking to myself, sorry, Debbie, this is a cynic in me, and hopefully I don't have attorneys coming down my back here, but I'm wondering about whether or not he's getting, if it's a fixed fee, okay, fair enough. I'm just wondering if it's tied to the value of the asset, because you could make the case that it's a little suspicious if she's only getting distributed 1%. And, obviously that means that the value of that trust is staying fairly sturdy. And if he's getting paid based on the value of the trust at a percentage wise, that would be a little concerning if I,
Yeah, with this big of a trust, I
because
don't
obviously that means if she's not spending any of the money, his fee gets to stay. Now, if he's getting a fixed fee, then you know what, that's basically it. That's fine. I'm just curious. Sorry for bringing it up, but I just
right. No, and I would expect in this situation that the accountant would be charging his hourly fee, right? Like, but
hello,
yeah, it doesn't
slightly
sound like
high,
he is.
slightly high.
Yeah.
Um, okay, so today we're discussing the three questions to ask about why traditional estate planning often fails families. And again, our questions are from the perspective of the family involved. So let's get right to question number one. My mother recently passed away, and in reviewing the family trust, we discovered that our cottage was left to our sister. Now everyone is upset. What can we do to rectify this? Debbie, start off with a maybe not so easy one for you here.
Right, exactly. Um, Unfortunately, this is one of the most common and emotionally charged situations I see. When someone has passed away, the options are really limited. You can't change the trust. I mean, there are some exceptions, so it's hard but not impossible. If the trust was properly signed and funded, changing the distribution structure after death usually requires the consent of all the beneficiaries or a court order. That's a really high bar. Sometimes mediation can help the family reach a compromise, especially if there was a genuine misunderstanding about what mom intended. But the real lesson here is prevention. During life, these surprises can be avoided with open and facilitated family conversations. After the plan is signed, I often meet with clients and their adult children together, not to debate the plan, but to clarify the why behind it. This transparency alone can prevent decades of resentment.
So how do families sort of be proactively incorporate this communication to prevent surprises? Um, and does there a role here for a mediator or an attorney like yourself after the fact? I mean, how does this, in your view, how does this unfold?
Right. Okay. So part of the estate planning engagement after,
Right.
like what I do, a good estate plan should include what I call a family meeting moment. And that's where the parents, with the attorney's guidance, explain their intentions in broad strokes, right? Like, and especially around emotional assets like a family home or business. The attorney can act as a neutral facilitator to keep things productive and ensure everyone feels heard. I'm often the bad guy. I very I really don't
I'm
let my
having a hard time envisioning this, but okay.
I really don't let my clients name like their children to serve as co-trustees together. My feeling is co-trustees, when you're using the children to serve as co-trustees, that ends up being no trustees. And so I like to be the bad guy in the family meeting because while a lot of people understand that serving as trustee is just thankless and just an awful job, some people do feel slighted. And so, I'll be the bad guy in the family meeting and I'll tell the children, I said, I would only let your parents name one of you to serve at a time. And we decided to go in birth order, or this one's located more geographically, close to where the parents were living. So I like to be the bad guy. I mean, I don't love it, but for my client, I'm happy to serve as the bad guy. And then after, in the situation where the parents had passed away, a mediator can play a similar role, and the mediator can help translate the legal into the emotional and help find common ground. Um, Families often underestimate how healing it can be just to have that structured conversation.
I got a question for you before we go on to question number two. In the example you just provided, how often, again, I know you have so many cases over time, but how often will you open the door to talking about bringing in a professional fiduciary, like a private fiduciary, instead of any family member being involved as a trustee or in the power of attorney roles? Does that come up, or do you find yourself ever bringing that into the conversation, saying, you know what? I think in this case, having somebody who's unaffected, compassionate but dispassionate to take this responsibility on might make more sense.
Oh, yes, I think I bring it up with 99% of my clients. I mean, I'm bringing it up every day. I think a professional fiduciary is such a good idea because they're doing this all day, every day. They know the job. They don't make expensive mistakes like a lay person, like one of the children. Um, and they know what they're doing. They've got all the resources and they can not only get it done for less money, but they can get it done faster.
Yeah, I agree with that last part. I've seen examples where things have not gone, especially if there's a lack of cooperation. I've got a case here recently where there's like three siblings that are just not cooperating in certain matters, and it just makes the role of the trustee, the life of the trustee, a major headache. So yeah, the idea of having a third party is something that I always kind of, again, I'm not an attorney, I can't make a final decision, but I can at least make the suggestion that bringing in a trustee is not a bad idea. In fact, I think it's a great idea. Okay, Debbie, let's move on to question number two. My spouse and I have been discussing our estate planning. We're thinking about naming our two children as trustees. Can you explain why this is a good idea?
All right.
The
It can
trick question.
exactly. It can feel like a good idea because naming your kids seems fair and familiar, but in practice, it often creates tension. Siblings have different personalities, financial habits, and levels of trustworthiness. And suddenly, I'm interpreting your question that you're saying that you're thinking of naming your adult children consecutively. So in that interpretation, suddenly one of the kids is in charge of managing money for the other. And that can strain even the healthiest relationships. And
Yeah, it doesn't take a lot of money to turn things sideways, as I can attest in my own immediate family scenario from back when my mother and aunt were in my lawyers and when my grandfather passed away. My mother and aunt had quite a bit of a falling out over a very small sum of money they couldn't find. And I mean small sum of money. And it just was like
right,
doesn't take six figures to turn family members into rivals or bring up
right. Like,
years of history of,
yeah. Right, I know. And like a trustee's job, it's not ceremonial. It's a business
it's
role.
administrative at worst.
Yeah, exactly. It requires objectivity, record keeping, and at times
Yes.
just saying no, right? And for so many families, it's better to have a neutral third party trustee handle administration. And the kids can serve as advisors or weigh in on big decisions. But we really, I mean, the goal of what I do as an estate planning lawyer is to preserve family harmony, right? So I think for most parents, what they care more than anything about is that their children remain close or at least have some sort of relationship after the parents pass.
I think you and I, okay, so we're on the same page here that naming family members as co-trustees is an ideal. And again, I think we also seem to be on the same page with regards to getting a fiduciary involved. Um, so are there, I'm just thinking out loud here, are there any other alternatives that we could or you would suggest? I'm thinking right now, being a cross-border financial advisor, we're trying to minimize tension. We're trying to maximize harmony. You work with blended families all the time. You have cross-border clients. We were just talking about one before we came on the air live here. So you're a very creative person. What are there some other things that you would consider? Is there anything we haven't brought up already that you would want to consider with these cases, especially where they get super complex?
Right. And so we've talked about the licensed professional fiduciary, and often that can be a good solution. But there's also a corporate trustee. And, maybe in a cross-border situation, a corporate trustee might be the better solution. What we really need to have is somebody that's familiar with the legal requirements in both jurisdictions, or at least can get themselves educated to a high level so that they know the legal requirements in the country, the
Yeah,
non-US country.
we'll use the US Canada angle since that's where our where I tend to spend most of my time. Do you know
Yeah,
one of the biggest mistakes? I'm going to give one to you. You know one of the biggest mistakes I could see happening, especially where the family are kind of entrenched on both sides of the border, like siblings, is the sibling in the US who's still close to the family member in Canada will try to name their Canadian sibling as the trustee of their estate.
I know.
And
Oh,
so maybe you could take, I know this is off, we're going off the range here a little bit, but why don't you just give us the 2-minute version of why this is not a great idea?
yeah, you just can't name if you're a US citizen and you're creating a trust in like a California trust, you really need to name a trustee here in California. If you name resident of Canada, now Canada can get their hands on and tax the trust assets. So it's
You create a
unnecessary.
foreign trust, right? Essentially what
Right,
you're doing.
right, right. So it's just
And it becomes a
unnecessary.
taxable nightmare here, even in the US. The IRS will look at it as a foreign trust as well. And I think the tax rates are in the 40% range if in that case. So, but I see that people all the same. Well, my sister in Toronto is my closest person. That's who I want to be my trustee. And,
I know.
sometimes, like I say this, I know I've said it about immigration law, and I know I probably said it about tax planning, but estate planning is an art as well as more of an art than a science. And not every estate planning attorney sees things the same. So that's why having an expert like you is so important. Um, why don't we get on to question number three? I know I took you on a bit of a side venture there, but I wanted to get your 2 cents on that.
No, and I'm so glad you brought it up because I've reviewed several trusts where the trustees named, the successor trustees named are, in India or Israel or Canada. And I I'm like I'm so glad that the client came to me to review their trust so we could get it fixed before it was too late.
All right. Well, glad I brought it up. Okay, so let's get to question number three. I have accumulated significant wealth during my career, and I want to ensure that my wife is taken care of financially when I'm gone. But I'm concerned about her ability to manage the proceeds. Can you suggest how I should deal with this without causing unwanted friction?
Yeah, that's a really sensitive and important question. It's common for one spouse to handle finances and the other one to feel less confident about money management. The key is to separate support from control. You can absolutely design a plan that provides full financial security for your spouse while protecting assets from mismanagement or outside influence, read predators, people who might prey on your spouse. For example, you can structure a trust to give your spouse full access to income and discretion for health and lifestyle expenses while ensuring that the principal is managed professionally and preserved for the next generation. And when done correctly, this feels empowering and not restrictive.
Do you call that testamentary? Is that like a testamentary? Is that considered a testamentary trust?
Yes.
So I thought so. I'm not a lawyer, but I was like going, that sounds that exactly. Okay. So in cases where a spouse may need support managing assets, so are there provisions that can be built into the plan? Is there other ways of doing it so they don't feel like they've lost their autonomy, I guess is the best way to put it. Aside from is there any other strategies, or do you think the testamentary trust is really the way to go?
It is, but also let's keep in mind who you're naming as the trustee. Like, this is where personality really matters. Like, is the spouse going to be feel supported by the trustee, or is this going to be more of an antagonistic relationship? Is the trustee all about managing and preserving the assets and not making distributions to the spouse in a way that it feels supported to the spouse? Or is the trustee, approaching it with ego and like, you have to come to me. Nobody wants to feel like they are getting an allowance or that they have to go ask,
Please, sir, can I have some more?
right, exactly, exactly.
Little Charles Dickens. So I know it's a thing I just thought of again. Nothing like taking Debbie on a little ride off the road here. Trust protectors. How often do you, when you're putting together a trust strategy like this, will you give them the option of adding a trust protector? Maybe for the folks that are listening in, especially for my folks and friends in Canada who've never heard the term before, maybe you could just explain what it is and whether or not you think it's a good strategy.
Yeah, I'm just going to give you a very simple
The cliff, yeah,
explanation.
exactly,
Yeah.
please.
But the trust protector, when I'm describing it to my clients, and and every single trust that I'm designing, I bring it up with them. And the trusts that are going to go on for a while after the client passes away, I often strongly encourage them to consider adding a trust protector. What the trust protector does, it's like the police officer over the successor trustees. So if a successor trustee is not doing the job well, the police officer can come in and fire the successor trustee. The trust protector comes in and out, in and out, and it's only if there's a need would the trust protector come in and perform an action. Another thing that the trust protector can do, and this is just a simple explanation, but over time, laws change, and
That's for
with
sure.
and sometimes they even change in a way that would benefit the trust. But if the client, the grantor, the client, the trust maker has passed away, now the trust is irrevocable, right? So it can't be changed unless we go get a court order, which is expensive and time consuming and slow. But if a trust protector is named, the trust protector can come in and modify the trust in a way that takes advantage of the law change. And the trust protector has to stay in compliance with the spirit of the trust. But if it's going to benefit the beneficiaries, then, you know, there should be a trust protector that can come in and modify the trust due to this change in law. Um, some clients don't like the idea that their trust could be amended after they die, and I certainly respect that. But some, see the benefit of having a trust protector because it's just another tool we can use to avoid having to go to court.
Okay, one last thing on trust protectors, Debbie. Again, you're very amiable to diversions off of the conversation here. One quick question. Can a trust protector be added to a trust after it's been finalized? In other words, there was none, if the one hasn't been appointed, can one be appointed after the fact? Or if it's not done when you put it in place, too bad, so sad.
Yeah, I haven't come across that situation, but I would think that one could be.
Say one of the trustees came to you and said, you know what? I need a third party. I need somebody to help me here. I'm having challenges. Could they get a trust protector assigned to help them?
Well, I think that in that case, either all the beneficiaries need to agree or the trust protector has to go to court to get an order. And in that case, I'm really not sure if the judge, if there wasn't agreement among the beneficiaries, then I can never predict what a court is going to do.
I'm not
But
expecting you to. And again, we're really having a sort of a Rogan-esque conversation here. So thank you very I was just thinking out loud here and sorry.
no, no
So
problem. Like I'm trying to avoid the favorite lawyer answer to every
it
question. Like
depends.
it depends, but
Yeah, I know it well. Okay, before we wrap up here and send you on your way, because you've been super patient and helpful today. So going back and looking at the Jimmy Buffett estate and that discussion we had on communications, on co-trustees, and planning what's Is there another protective step a family could take today? Like listening today, they're listening it or watching or however they're consuming the content. Is there anything they can do today that will make their estate plan more resilient against these common failures? Because I think we've really done a good job today, of anything, of illustrating how things can fall apart, even if they're well constructed, on paper.
Yes. Okay. In a nutshell, schedule a checkup with your estate planning attorney. For so many people, they treat it as a one and done transaction. Oh my gosh, Wayne, there are so many trusts out there. They're called AB trusts. I don't need to get into the details, but they are unnecessary in today's environment with our federal estate tax exemption being so high.
15
And
million.
the problem is, especially in California, where community property and we get the double step up with these AB trusts, the families are going to lose the second step up. So it's going to be really expensive. So please, everybody, if it's been more than 3 years, please go schedule right now a checkup with your estate planning attorney. So
Yeah,
many
3 years.
people,
I say 2 to 3 years, minute maximum 5. I tell
yeah,
clients all the time, review your estate plans. Time passes. To quote Don Henley in the Eagles documentary, which you haven't watched, you got to see it. His great, the best line ever in the whole. I'm going to take it away right now. The best line in the whole documentary. They're asking Don Henley about why Don Felder didn't get his share of the money, and Henley looked into the camera and he said, "Time passes and things change."
yes, yes, yes. And can I just add, since I have the attention of your listeners, and I think you can tell how passionate I am about this
100%.
topic. Don't just have your plan reviewed, but also make sure all of your assets are in the trust. That's how you avoid probate. This single habit can prevent nearly all the problems we've talked about today. And, as Don Henley pointed out, estate planning isn't one and done. It's a living process
Time
that
passes and things change.
exactly.
What a line. What a
And the
line.
I know, right? And then the last thing is please don't keep your estate plan a secret from your loved ones. Communication is so important for a plan to work.
Yeah, that's one thing I don't know, our generation, boomers or Gen X. I'll give you the benefit of the doubt, Gen X.
Thank you.
My better half insists that she's Gen X, although unfortunately she's incorrect. She listens, so I had to put that in there. So there's this sort of keeping everything close to the vest. Don't tell anybody anything. I'm sure you come across it all the time. Okay, one last thing. I promise, Debbie. So I know you're an expert. We had you on before talking about the Brady Bunch family, so blended families. So for blended families, cross-border families, like the ones that we have in our audience that you work with, that I work with, how can incorporating these three critical elements, let's talk about them one last time: communication, avoiding co-trustees, I'm going to put it right out there, and planning, help avoid these pitfalls, like we saw with the Buffets. Just one last little dissertation, and then away we'll go.
Yeah. So these three pillars, communication, the right trustees, and planning, these pillars are non-negotiable. Communication understands that everyone understands I'm sorry, communication ensures that everyone understands both the what and the why, and choosing the right trustees, not just the ones who you love, but the ones who can do the job, effectively administer the trust. This is what makes sure that everything goes smoothly and fairly. And ongoing planning ties it all together by making sure the documents, the assets, and the family values, they all stay in sync. And when these three things work in harmony, you don't just protect wealth, you protect
And
relationships.
you keep harmony, right? Which is what we're all, we're here. Estate plans are intended initially to care for and protect the people that you love, right? So, I mean, creating
Right.
harmony. and not, war.
At the end of the day, I say this all the time. What I do is I'm keeping families out of court and out of conflict. And I tell people, my clients, when they come to me, I said, what you're doing your estate planning, it's such an act of love because while we do benefit from doing our planning, we're really doing it for our loved ones.
Right, bang on. Okay, so this has been an exceptionally informative podcast today, and I cannot thank you enough for taking time out of your day. I know you're busy, so I really appreciate it. So I got to ask this one last question, and that is this. How do people find you? How do they contact you? People listening today, I can't help but they're going to say, we need to talk.
Yes,
So what is the best way? What is the best way for people to contact you? Is it phone, email, website?
yeah.
What's the
Phone 424-248-0283 and my website dbabblaw.com, dbabblaw.com.
Debbie, thank you so much. It was great seeing you again. Thank you. Thanks for the newsletters. Keep sending them, all right? Like I said, I do read them.
Such a pleasure. Thank you so much, Wayne, for having me on here and letting me, share with your audience
Yeah.
this really
Great
important
stories.
information.
Great,
Yeah.
incredible story. Debbie Babb is a third generation Los Angeles attorney, and she specializes in estate planning for complex family dynamics. Think Brady Bunch family, blended families. She's a real pro. Debbie, thank you very much. We'll see you again. I look forward to bringing you to the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification of when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.